know if we have to.
What's it? I'll look for it on Senate. Oh, sorry.
Yeah, Kurt sent it to me and I can't for some reason.
Okay.
Now I can't access it. Weird.
Do you want me to do it?
No, I just, what?
Go live.
Okay, sorry.
We're live. Go ahead.
Okay. Good afternoon. This is the Board of Standards and Appeals Public Review Session for August 24th, 2 p.m. The first case that we'll be discussing is 24708BZ, 3454 Nostrand Avenue, Brooklyn. This is a review session, no calling in.
Right, and before we continue with that, I just want to let people know who were listening to the morning session. We had two cases that we were not able to get to this morning, and we will try to get to them after the cases we have in this afternoon session. So stay tuned. We're trying to get to all the cases that were scheduled to today, for today, but we had technical difficulties caused by an East Coast wide Zoom and YouTube video connection failure. Okay, drawings on this one, drawings were submitted to show acoustical fencing and so on, which was shown on the previously approved drawings and installed for the prior operator of the drive-through, who was known as Louisiana Kitchen. In the realm of buffering, the residential neighbor, from the effects of the cars lining up, that wall, acoustical wall doesn't really. There are windows at the second and third floor with direct views into the driveway and parking area and trash enclosure. And if I lived there, I would not be a happy neighbor. I question the need. So looking into like, is there a way to solve it? I question the need for two ways in and out from the adjacent parking lot where there are only 5 parking spaces, and why the entry to the drive-through can't therefore be pulled away from the property line to allow for the creation of a planting bed with dense high buffer trees, and would require the relocation of the trash enclosure a little bit further over against the building, hence facing the street. But of course there would be an enclosure with a fence. It already faces the street anyway. So the actual field sound meter readings were provided and appear to show limited increases over ambient levels. The report doesn't indicate how many readings at a given point were taken or at what time. This meter reading methodology pretty much followed our requirements under the administrative notice, but we talked a lot this morning about the excellent field light level reading report that was prepared that followed to the letter our, and even took it further because I think it's maybe even better than what we imagined, the administrative notice about how to handle light readings. So they turned the lights off in the entire site and took readings, all of which were 0, which is good because it meant there was no light filtering from somewhere else that would increase the readings. And they also took photographs, which I thought were really helpful. So just in case you were suspicious, they took photographs that showed this dark, dark site with no lights on. And then they turned the lights on and they took the same readings as necessary. And it turns out that the drive-through is very dimly lit to begin with, the one that enters right next to the residence. So light spill into the neighboring resident is really not an issue. And those were my comments. Vice Chair Shanda?
Okay. This is an existing the operator has changed, but the facility is a prior existing facility where only the operator is changing, and there's no change that is being proposed to the layout or the configuration. So I primarily focused on the signage, the lighting, and I think when it was the Louisiana Chicken, I had asked for more planting along that triangular section because though we had asked along the rear lot line, I think various studies they had provided indicated that they couldn't shift the drive-through. So I'd asked for more landscaping along that triangular section in the corner. I was very pleased with the sound level analysis that was done and the light analysis that was done. And it seems we are all in agreement of the way the light level analysis was done and can become our future standard. But other than that, I had no comments.
Okay. You mentioned a prior study that you just remember them talking about shifting the, I don't
Yeah.
remember.
Yeah.
Maybe they could, if they can dig up that study, so they could provide that to us, but I don't really get, other than the turn. So I was trying to figure out whether there's an issue if you just move it over like 5 feet, whether you can still make the turn, or you drive up and then you do like a little bulb out turn, because it's not all the way, it's not that the residential property is fully adjacent, it's that at a certain point, there's windows right into the site, and at another point there aren't. So if you move the access point just 4 feet, 5 feet over, drove straight up and then bulbed around to make the corner, whether that would work. I don't know.
Yeah, I think we had similar kind of question at the last one also, and I seem to recall they had provided diagrams to show if it was feasible or not, and we kind of then said, okay, provide more of a heavy loaded acoustical barrier along the rear lot line, and more we had asked them to make the buffering at the corner, though that's at the corner, it doesn't quite work well for the residents right next to it, but we said whatever it can do to reduce dampen the sound more.
I don't think it actually does anything. It's decorating a place that only the drivers can see.
Yeah, and the menu board is located more at the angle. It's going to bounce off onto the building that is next to it. It's a 1-story full lot coverage building. So we were, in this case, we were like, okay, just make sure you provide an acoustical barrier, because where the menu board is, I would say though, add a note along the wall that says turn off your radio or anything, so that we do not have that same issue of somebody who's driving by has a radio on and the window is rolled down. So that should be something going forward. Every drive-through we have that additional sign that is added.
Mm-hmm. Okay. All right, Commissioner Otley-Brown, thank you.
I have no additional questions. I feel like the use as a Starbucks will probably be more benign to the neighbors behind, because I don't think it stays open as late as the Popeyes did. But they could clarify that at the hearing. But I believe that Starbucks in general closes like by 9 in the evening.
Okay, so that's fair. Let's find out what time they close. Okay.
Mm-hmm.
Commissioner Sheta.
Thank you, Chair. I want to praise the applicant for the work that they've done. Actually, we didn't ask them to do what they did, but they were generous to go to the notice and read it and apply whatever in it and submit what they submitted. So thank you so much for that. One quick question that is not gonna affect my take on that case. The readings that were taken for the menu board, were these readings taken while the AVC on or off? So in other words, was this an AVC on operation, or it was a controlled outbound operation? Apart from that, it seems like fine for me to go ahead with this application and close it.
Okay.
If there is nothing else.
Yeah, I just want to clarify one thing. Our excellent project managers, when they see these applications now coming in new, send them a copy of the administrative notice and say, please do this. So actually, it was requested by our project manager, which then is an opportunity to eliminate endless hearings in begging them to do something if they listen to the requests of the project manager and actually are responsive, which this applicant has done, and I think that's wonderful. So
and I want to whisper to other applicants, you see, when the submission is nice as that, it goes quick. So here we go.
yeah. Yeah, whisper.
Yeah, yeah. Yes,
And
I whisper.
hear us. Okay. And Commissioner Shabeta, thank you.
There's nothing further from me. I was satisfied with this application. I think that the applicant and its counsel did a great job, and I'm glad to see it's a council that appears before us quite a bit, and look forward to settling these cases much sooner.
Mhm. Thank you, everyone.
Item number 18, 16209 BZ, 30-33 Steinway Street, Queens.
Okay. Yeah. Okay. I just want to remind us, because this has been going on for a little while, that this application is both a request for an extension of a term and an amendment of hours to allow 24/7 operations. And a correction is also, which is not an amendment, it's really more like a correction, is being made to the floor area for to show 17,866 total gross square feet for the operation. And the architect submitted a letter explaining why there was a recalculation like that. We also needed proof of continuous use since the expiration of the term in December 2018. And this was provided in the form of Google Street View, which we've accepted in the past as proof of continuous operation. As to the location of the R5 zoning district boundary, which is something that I was concerned about, and the extension by a previously granted 73-52 special permit to move the boundary line. They did clarify somewhat, but I would ask, because I'm going to recommend that we close this one, but I would ask that the drawings be tweaked just a little more for clarity for the next time the applicant comes back and the board is confused again about that boundary line, that they do the following changes to the drawings. On P-100.02 and P-400.02, both of which show the same site plan, indicate the location of the R5/C4-2A district boundary line with an arrow, as instead of having just the title there that sort of floats without purpose, you point to the line with an arrow. That's an architectural convention. Indicate the location of the, with an arrow. Show the dimension of the distance between the district boundary line and the property line. Is that 100 feet? Or is that 90 something feet, the actual property line to district boundary line, because maybe the shape of the block is reducing? But it wasn't clear to me where that 90 something foot measurement is from, because when you look at district boundary line analyses in a C42A, the typical is 100 feet from the center line of the block or whatever, right? So that they need to make sure that they're showing us the accurate location of the district boundary line. Show the dimension between the district boundary line and the line of extension that was granted under that special permit. Typically, the extension is 25 feet. So I'm guessing that that's what the extension was, but I don't know. You need to go back and check the resolution that granted this and the approved drawing to be clear, where did the extension move to? Do the same, show the dimension between the district boundary line and the extension, both on the site plans and on the floor plans. That way we can know that the entirety of the PCE is located within the boundary line that's now being treated as a commercial district, right? And then, yeah, okay, that's please an instruction to the architect to make those corrections to the drawings. With respect to the community's trash concerns, I just want to say that, like, the community was concerned about there being a lot of trash buildup here. We can make as a condition to the approval that the about the representation in the applicant's cover letter about the frequency of collection, which is 6 nights per week, alternating recyclables and non-recyclables, that the trash is stored in the cellar until it's taken outside for pickup, and that no trash shall be stored or disposed of in the rear of the building. So if we make that a condition, at least the community board and neighbors could rely on that for any future potential issues. And then that means the applicant would have to come back for a compliance hearing, which it should of course avoid. So those are my comments. Vice Chair Shanda.
So after the first hearing, I have been by that site a couple of times, and especially along the rear. The applicant has stated that all their pickup is along the Steinway street and not from the Newton. So the trash buildup, first of all, I did not see, based on my couple of site visits, I have not seen any trash in the rear portion and not even in the front portion. So that's one. So the second part is that this applicant has stated that their trash collection is from Steinway and not from the Newton. So I am a little hesitant about putting that condition, partly because it is one of those corners. There is a small triangular piece from that building, which is kind of in a no man's land, which doesn't even belong to this property. And this is, you know, if there is any trash that is being gathered there, it is not because this particular operator is dumping there. It is some other person who is dumping there, not even maybe the tenant, it's just some local people who are dumping there, because it's almost a dead area. Nobody really keeps an eye out on that section. And it's the owner's responsibility, I agree, to make sure all the property frontages are free and clear of trash. But I don't think that obligation should be put on this particular PCE because they are making sure their drop off and garbage pickup is happening on Steinway. And the complaint was for the Newton, not for the Steinway.
But this PCE occupies, if I've got it correctly, the entirety.
There is another tenant. Foot Locker occupies the ground floor.
It says cellar and
So-
second floor. Okay.
So I will be hesitant in putting that condition. It almost seems like we are expecting them to make that mistake, which I think they have indicated they're doing everything in their capacity to make sure they're picking up the garbage. They have made the provision for the garbage pickup in the way that it should be.
Okay, so how about we modify it slightly, because they still do have a trash obligation, right? Because every commercial entity has to have their own carting company. It's not shared with the other tenants.
Right.
So their cover letter says that they have collection 6 nights a week, alternating recyclables and non, and that their trash is stored in the cellar until taken outside for pickup, and that none of their trash will be stored outside the building. How about that? Or we just take out that last one, that their trash shall be stored on the inside of the building until ready for pickup.
Yeah, and
It's obligating the PCE, right, to still do what it's supposed to do. Is that okay?
okay.
All right, so I take out that last sentence. Okay. All right, anything else? No, okay, Commissioner Otley Brown?
They submitted the Google Street View photo that was dated November 19th and stated that they actually filed the application on January 2020, which was 2 months later. So I'm okay with that.
Great.
For continuous use, rather.
Okay. Commissioner Sheta?
Thank you, Chair. I don't have any additional comments on this.
Okay. Commissioner Shabeta?
Nothing additional from me.
Okay. Good. Next.
Item number 19, 12610BZ, 856 Renson Avenue, Brooklyn.
Okay, this is a new case. So we have proof of notice of hearing to officials, but sorry?
No, I'm sorry. I forgot to note that. I apologize.
Okay, however, I don't find, and I need our project manager to search and send me a copy. I don't find proof of service of initial application to officials. There is a folder with that title, but when you look inside, that's not what you find in that folder. So I need proof of service of initial application to officials. However, since the community board issued a recommendation, it's likely it was served, but we don't have it in our record unless it didn't make it properly into the record. So community board recommends approval. We have fire department letter of no objection. No DOI is required for an extension. And this is an extension of term and an amendment requesting hours of operation to be 24/7. I don't have any comments other than we need to make sure we have proper service. Anybody else?
No comments.
Okay. Commissioner Brown, no. Commissioner Shetta?
Yeah, Chair. I believe it's a very minor thing. They have a typo in the statement of facts that's referencing P-200.00. I believe it should be 0.01. Apart from that, nothing from me.
So sorry, that's a reference to what?
It's a reference to sheet P-200. And I believe it should be 0.00. And I believe it should be corrected to P-200.01.
01.
It's on the statement of facts, page 2 of 3, on the 4th paragraph, under extension of term and amendment of previous board approval.
Okay. Okay, good. Thank you. Commissioner Shabetto.
Nothing further from me.
Okay. Thank you.
Item number 20, 19313BZ, 4770 White Plains Road, the Bronx.
Okay. Also, this is a new case.
New case.
So this is an extension of time to complete construction of a parking lot. So there's no notice requirements. In comparing the BSA approved set to the DOB set, I note that the dimensions on the dimension plan don't match the BSA approvals, especially with respect to the width of the planting beds and the queuing count and stacker layout. There's also a fence added in the parking area. I'm not sure for what reason, maybe to separate the type of parking, one type from another. They need to update the Department of Building set to the extent that it doesn't provide for the amount of planting, and resubmit that as a post-approval amendment. And where amendments to the BSA approval may be required, they need to call them out on the drawings for board consideration, because there's a lot of differences about the layout, and I don't know exactly, what the board considered when it was looking at this layout, and if there's any concerns, because there are actually fewer or let's say a different stacker count, right? And a different layout of the parking. They also need to provide the prior BSA history resolutions. They only gave us a history, but they didn't include the resolutions of that history. And just a note that they're requesting an extension of 4 years. They haven't started the work on the parking lot because they were doing the interior renovations of the building to which the lot is accessory. Okay, Vice Chair Shanda.
One of the questions I wanted, if the building is fully occupied or not. I didn't have any other comments with regards to the layout.
Okay. Commissioner Ollie Brown.
No additional comments.
Okay. Commissioner Sheta.
Thank you, Chair. The only thing I have is, my understanding is the building is wrapping up construction, and the parking lot is not, and that building is going to be served by the parking lot. So my concern is it possible that the building start being in operation and the parking demand is not satisfied?
So technically, if I got this right, technically, you're not allowed to get a certificate of occupancy for a building that doesn't provide the required parking. So unless you say to DOB and DOB is persuaded that I'm going to be using temporarily the lot down the street or something like that. Technically, that's the way it's supposed to go. I don't know, we can find out. So that's a good question. Maybe that's behind what Commissioner Vice Chair Shanda was asking as well.
Yeah,
Yeah, okay. Thank you. And Commissioner Shabeta.
Nothing further from me, Chair.
Okay.
Okay, item number 21, 2017, 142BZ, 3000 Coney Island Avenue, Brooklyn.
Okay, this one we actually put on the calendar and advised that it's a very problematic case. We reviewed this a long time ago. We actually heard this more than a year ago and had, or let's say didn't hear it. We had a review session. And during the review session, we all gave our comments and we concluded that we didn't have the authority to consider it because the DOB objection was wrong. So we don't do this often. We took it off calendar to get a new objection because we figured that can't take that long. And a year and 4 months later, or almost 5 months later, we still don't have the proper DOB objection and tons of excuses from the applicant about why they should have more time. And by the way, the case was filed in May 2017. And I know our project manager, I believe this is Jella Prenga, was very helpful in giving us a timeline so everyone could read along how long this has been here. Case was filed in May of 2017, received a first dismissal warning in October 2018 because the applicant failed to respond to the notice of comments, and then and didn't respond to that warning in October 2018. So they received a final warning in December 2018, and then persuaded us on that final warning to calendar it for an April 2019 hearing. And still April 2019 hearing, and still we're kind of nowhere, and we are in the same place where the applicant is saying, please don't dismiss us, a little more time, we're almost there, etc. So my feeling about it is 3+ years of waiting for this applicant to get their act together is too much to ask of the board when we have such a heavy calendar. And what I think we should do is dismiss this for failure to prosecute without prejudice. And then when the applicant is finally ready with an application that both has the proper objection and responds to all of our comments from more than a year ago, then they should refile. So that's my recommendation. Any Commissioner, Vice Chair Shanda?
No, I agree with you.
Okay. Commissioner Otley Brown?
I agree with you.
Okay. Commissioner Sheta?
yeah, same page.
Same page. Commissioner Shabeta?
I'll change it up. No opposition here.
No opposition. Same page.
You want to be opposition?
So we do, technically though, this is review session. Can we make a motion to dismiss right here?
Mhm.
I think you can. I think you can because you.
What? Say it again.
I think the applicant should have the opportunity to address the board.
Oh, okay, he can address the board, but I'm just warning him in advance. He's not going to talk us out of it. We've been at this for 3 years. It's enough. Okay.
Okay,
Yeah, because usually when we make a motion to dismiss, it's the applicant has already, most of the time it's not dismiss, it's withdraw, right? And the applicant submits the request to withdraw. So that's another opportunity. I don't know, it doesn't really make any difference. But yeah, I see Commissioner Sheta's hand up and I see Ms. Prenga's hand up. So go ahead, Commissioner Sheta.
I would say if we put this on the calendar under the intention that we're gonna dismiss it, and the applicant didn't respond at all, I would say vote on it now.
No.
But since we got like a request for an adjournment, I would say it would be wise to like listen to him or her and then make our minds. I'm fine with that scenario.
Okay.
Like to give him a chance to talk shortly, not for so long, see what his point is, and most likely I'm not gonna be changing my take on it, but
We've already heard his point. Commissioner Otley Brown, go ahead.
Did we get a request for adjournment
Yes, just recently.
Yes, we did.
just recently? Oh, okay, that was my
Yeah.
question.
So
We
he
got a
said,
request, just like, I don't know, Friday or something, and saying, oh, please, the alteration type 1, something or other, they need to make me file another, I don't know what, et cetera, et cetera. I don't remember the details, but that's what's been going on for a year and a half.
And that didn't reply to any of the substantive issues we had about the program and the justification for the application. So I personally am in favor of just dismissing it.
Right, okay. And I just want to recognize Ms. Pranga, go ahead.
oh, yeah, I just wanted to clarify that he wanted the adjournment and he also said it would be really difficult to be here,
Oh,
but we advised him he should try to come. So I don't know if he actually will.
all right, so if he doesn't come, then it's that much faster, but I'm going to make a motion to dismiss without prejudice and file again when they're ready.
Yeah, he had a family obligation, so.
Okay, that's the way it goes. All right.
My only question is if it's pre-close, if it's before we close, I believe, then if we dismiss, it could be without prejudice. Is that correct?
Well,
And
we
it's-
don't have jurisdiction right now.
No, so
Sorry.
let's get our deputy counsel to respond to that, because I think that's why he raised his hand.
Sorry.
You're muted, Chase. Chase, you're muted.
Can you hear me? No?
Yeah.
Our rules, section 1-12.3 state that a dismissal action within 1 year of the date of mailing of the board's notice of comments must be a vote by the board at public hearing after notice of that. It sounds like from the discussion, this is outside of a year from the notice of comment. So the board could decide now.
You could decide now.
Under that, I'm okay with doing it now.
Me too. I don't see any reason.
Yep.
Okay, so
So then I would like to make a motion to dismiss this without prejudice and welcome the applicant to come back when he's ready with the applicant.
so Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shepherd,
I
Commissioner Shabeta.
Aye.
His application is dismissed.
Great. All right.
Okay, so now we've gone through those 5 cases, so now we commence with the public hearing.
Correct.
So the first case is 24708BZ, 3454 Nostrand Avenue, Brooklyn, right? We want to start, we're going to keep going with these.
Yes, we're staying with the afternoon session, and then at the very end, we'll try to pick up the 2.
Okay.
Okay. So this is Mr. Palatnik and company. Have them in. We have Elise. Is that who's on this? Who's registered for this? Is this Elise?
Sorry. This is, it's Paredes. Patrick Paredes, hold on, sorry.
She's raised her hand, so yes. Okay.
Patrick Paredes is a public, sorry.
Hello.
Yeah, hi.
Hi.
Eric and Elise and Mr. Amato and Mr. Paredes is a public.
Okay, Amato, we're going to allow him into. Okay.
There's also Corey Bertram.
Oh, is that in
Okay.
the- I'm sorry, I missed that one.
We have hands up from Giuseppe Anzalone.
He's
Yes.
yeah, he is in charge of that group with the Patrick and the Joseph.
Okay, and Corey Bertram? is
Yeah,
he- Okay, and Alex Levkovich is the architect?
no, that's the architect
No,
you just talked about.
Alice Lefkovich is the case we just dismissed.
Yes.
Okay, so he's here, but I'm sorry, yeah. Sorry, Mr. Lefkovich, we dismissed the case. So Mr. Bertram should be allowed in, Corey Bertram?
Yes, he's from Starbucks, in case you have any, he can clarify. afterwards about
And
it.
then
Giuseppe. And
this person,
Hello?
hi, Mr. Lefkovich, we already dismissed that case.
I'm sorry, I was present during that. With all due respect, I think my request for adjournment was not accurately represented to the other members of the board.
Mr. Lefkovich,
Mr.
that was a
Lefkovich,
review session and now you're out of order. That was a review session where it was not possible for you.
So at least give me the opportunity to speak for myself tomorrow. It's not fair.
So, sorry, sir. You know what? I think you're going to need to take this up with our executive director and counsel. We made an executive decision to dismiss your case based
But
on.
at least give me a chance to voice myself. It's my letter was not properly represented.
Mr. Lefkovich, the board saw you, I'm sorry, Madam Chair.
Okay, so he's muted. We're not talking about his case. We're talking about a different case. You cannot call in to talk about somebody else's case while we're talking in the hearing about someone else's case. And the prior discussion was an executive session where no one from the public is allowed to speak. So, okay.
So we're now discussing 24708BZ 3454 North Shore Avenue, Brooklyn.
Correct. And I see Mr., I think it's D'Amato, is that correct?
Yeah.
He should be accepted?
Yes.
Okay, so, oh, he's permitted. Okay, talking permitted for him.
Yeah, he's on the list.
Okay. Great. All right, so please proceed, Ms. Fuller.
Raise your right hand. Do you affirm to everyone? I can't see other people, but I'm assuming they're holding their hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Please unmute yourself and respond
I do.
for this case.
I do.
Mr. Bertram, identify yourself, though.
Yes, I do.
Who is that, Mr. Bertram?
Yes.
Mr. D'Amato?
I do.
Okay,
Is there
please
anybody else?
proceed.
Elise Fullader from Eric Palatnik PC. Thank you for having us this afternoon. Firstly, I wanted to say that I was not the project manager on the previous application, but just a year before we filed, this had come as a Popeyes. And Corey, please tell me if I'm wrong, but it does close at 9 p.m. So this site will not affect negatively residents as they sleep at night because it does close at 9 p.m. And they looked at multiple ways in the reviewing the records. I remember looking through and seeing that landscaping was put in, the soundboard was adjusted, and various items like that. So I believe that I'm just repeating what Commissioner Chanda said, and those items did appear to have been reviewed just a year before we applied for this special application. So that's what I wanted to say in terms of layout. And I don't know if you want to add anything about the layout, but we did review it.
Oh, so this is one of those classic, no need to speak while you're ahead.
Yeah.
I think everybody expressed
Okay.
basic satisfaction with the application, and I don't know who the person was who handled the lighting analysis.
He's on the call. So.
Thank you, Mr. D'Amato. Excellent, and
My
I
pleasure.
don't mind if we use it as a model for our future applicants, because without asking a single question, apparently, you got it right the first time, 100%. So I want to just say A+. Thank you very
much.
Really professional, excellent work. Okay.
Our pleasure, our pleasure.
Okay.
And I want to point out, though, at this site that we were able to do that because it did shut off at 9 p.m. So you could see the hours that they spent many, many hours turning on and off lights. So that was much easier at this site, and they did an amazing job. Thank you.
Right, but there is that like master electrical switch where you can turn the whole thing off right at the main. And so it's true that if you're just one tenant amidst many, but most of the time when we're looking at this, it's one tenant. It's not, or one user, it's not many tenants. So, okay. So I want to thank everyone, and I don't think Oh, yeah, so Commissioner,
That I had something.
Yeah, so the menu board sound consultant couldn't be on the call today, but I called and asked, and they said they took the reading sometime in the morning, and he could not confirm or deny if that, you said AV, if anything was shut on or off. He said he.
Yeah, the AVC, my question
Yeah,
was
I
the
said
AVC on or off, yeah.
And he wasn't sure, I'm sorry.
That's okay, that's fine.
okay, okay. And Commissioner Ollie Brown, you have your hand up?
So going forward, what will the hours be at this location?
I know it closed at 9 p.m.
Yeah, so right now we are open from 6 a.m. to 7 p.m. just because we're running a little bit shorter hours right now due to the pandemic. But hopefully if the world gets to a better place soon, our hours are 5:30 a.m. to 9 p.m.
Thank you, Corey.
Okay. So it's okay that we say the hours are 5:30 a.m. to 9 p.m. on the resolution? You're okay with
Yes.
that? Okay. Okay, great. That's Monday through Sunday?
Yes.
Okay. Great. All right, great. Anything else? Was there anything that we wanted to clarify? Anybody?
Commissioner Shonda has her hand up.
Oh, I didn't see it. Sorry, I was typing. Go ahead.
It's okay. I think just even though everything looks good, I think as a standard for all drive-throughs, if we could add that note, turn your radio off or something, which basically kills any possible other ambient noise. So these are just signposts that you can put along the wall that the driver is, or wherever the driver can see to turn the noise off.
Right.
Coming from their vehicle.
Good idea. Good idea.
Audio coming from their vehicle.
Especially when you come for coffee at 5:30 in the morning.
You're listening to the news.
Radio, you're listening to the news and you need the radio to keep you awake while you're driving before you get your coffee. So yeah. Okay, so then I would like to there's no submission. I'd like to make a motion to close this.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
And I just want to remind all listeners, other applicant listeners, see what happens, just like Commissioner Sheta said earlier, see what happens when you follow all the instructions of the project manager in advance without having to be asked by the commissioners to do it again, and you follow the instructions carefully. So it takes one hearing, yay. Thank you very much, all of you, for your participation and good submission.
Thank you.
And for their clarification.
Public.
Sorry.
Public, oops. I was sorry I didn't invite the public, mea culpa. Okay, are there any members of the public who would like to speak on this item?
24708BZ, 3454 Nostrand Avenue. I'm sorry.
So it's apologies, maybe we'll learn something now. So there are two members in who have phone numbers. Last digit of 807 and last digit of 949. I think these might be the ones we asked earlier. So
807's on a different case.
807 is on a different case. How about 949?
949, I don't see it on this list.
Okay, I think that person might have called in this morning and never spoke when we recognized that phone number.
This is for the Willets Point.
Maybe, I think that was the 807 number. So I'm going to allow the person with last three digits, 949, to speak and just identify yourself and say what case you're here for, okay? Person with last.
I was here for, hello? Can you hear me?
Yes.
Yeah.
Yes, I was here for the Nostrand Avenue hearing, so I have no comment, no additional comment.
Oh, okay.
Oh, you were here, the Starbucks?
Yes, ma'am.
Okay, so you don't have any comments on this. You're part of the team?
Yeah, I'm just calling in remotely.
Okay, oh, I see. Okay, good. Thank you very much. All right.
Okay.
All right, then. So we will put this on for a decision as soon as possible because you don't have a submission. Okay,
That's what I wanted to ask, and you answered it, so thank you very much.
there we go.
No, hold on. Don't they have to revise the plan to put the notes saying?
Oh,
no-
I'm sorry. Just that little one note. No,
Okay,
so
no
just
plan for now. Okay.
revised plan with no radio sign.
Okay.
Words to that effect, something friendly.
Okay.
Yeah, I think we should have a standard language. Maybe we applied it in a prior case, so maybe that can be shared by the project manager with you.
Yes.
I appreciate it. Yeah, that would be helpful.
Maybe
Okay.
the White Castle case we just did had some language I can check.
Right. Chase, did you want to say something?
Giuseppe Anzalone is here for this application as well. I don't know.
To testify or
I believe he is the architect.
Yeah.
He's the architect, yes.
he's the architect? So thank you for calling in, Mr. Angeloni. His hand is up. Let's let him in case he wants to say something. Talking permitted, allowed to talk. There we go. If you'd like to speak, Mr. Anzalone, please do so. But you're muted.
I have no comment. I'm just listening in case you guys need me.
Oh, okay. Thank you. Thank you for bringing your entire team. It's really good. Okay.
Yeah,
He actually wrote a letter explaining to us how the lighting measurements were done, and he didn't need to do that. So he made my job, he made it easier. So thank you so much.
Thank you. Okay. Is there something you wanted to add, Tony?
No, I was just going to say that he's identified as a member of the public. Isn't he supposed to be identified as an applicant on this
Okay.
registration
Next
form?
year, He'll do it like that. Okay.
Okay. No, I'm just looking at it and I saw he's public, not applicant.
Okay. All
Okay.
right. And so you'll revise the plan with the radio sign, and I can see it's not going to take long to do that kind of a correction. We'll try to put you on for decision as soon as possible. Okay.
Thank you.
Okay, next case, 16209BZ, 3033 Steinway Street, Queens.
Okay, this is Ackerman.
I don't see anybody in here.
So on the last hearing, it was Frank St. Jacques. Do we know?
I know on my next case, there's somebody else named Joe Garner going to be representing him, so maybe for the same case.
Yes, that's correct. Same thing for this.
Okay, so we'll let Mr. Gahan in. Okay. Okay, please, when you can hear us, Mr. Gahan, please state your name. He's gone.
Mr. Gahan, okay.
Can you hear us?
I can hear you.
Please state your name.
My name is Joe Gayon.
Okay.
I'm from the law firm Ackerman.
Okay. Go ahead. Are you expecting to be joined by anyone else?
Just me.
It's you. Okay.
Okay, let me swear you in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
I do.
Okay, so the case we're discussing is 16209BZ, 30-33 Steinway Street, Queens.
Good afternoon, Chair, Commissioners. I'm just going to jump right into the comments that you had with respect to the revised plans. We will make those revisions as requested, and we can have that submission to you within the next week or two. And I'm just confirming that we are okay with the revised conditions that you proposed. And I believe those are the only outstanding issues that you asked the applicant to address.
Yes. Great. So you're going to make those changes on the drawings, which are very small about the district boundary line. That's really it, right?
That's correct.
Okay. And I recommend, you're with Ackerman. I recommend that you just have the architect listen to that little piece on the review session so that you don't have to translate it, and just have them listen to that section of the video so that they can follow along and just make the changes as I'm speaking. Okay?
Understood.
Okay, great. All right then. So there are no other there's no substantive issues on this, but we should invite the public to speak. So let's invite public. Show that screen. So anybody who would like to speak on this application, which is
16209BZ, 30-33 Steinway Street, Queens.
okay. And how much time do you said you needed? How much time?
About a week or two.
Okay. So let's see.
And we're clear, Madam, I think this is the one you talked about the trash. Are we clear about that?
Yeah, he's okay.
Okay.
He said they're okay with the conditions.
Okay.
So, okay. I only see that 1516 number that's unclear. Does everyone know? So Benjamin Diamond, is he here for a different application? Does anyone know?
I think he's, no, 516, what's the number?
No, Benjamin Diamond. I'm just trying to identify these people who are in the waiting room.
Benjamin Diamond is here for 19313BZ.
Okay, and Greg Galzuski?
Galsuski is for
Same application.
1993, same application.
Okay, so this is just this 516807, which maybe Mr. Sweeney, but I don't know. So I'm just gonna let that person in to just identify what case he's here for. So
that's Greg Galazweski. That number there you're showing right now, 516807. He's the architect for 19313.
So he's in both. Okay, let me just phone number 807. Can you just identify yourself, please, and unmute? Or maybe, because Mr. Galzwetzky is in also regular Zoom.
That's his phone number.
Oh, okay, so we didn't move him back out. Okay, great, thank you. All right.
So we're gonna close this?
So we're gonna close, yeah. Motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, close. Okay. Next item is 12610, new case, 12610BZ, 856 Renson Avenue, Brooklyn. Mr. Gayon is on this, for this. Raise your right hand. You're the only one, right?
I'm the only one.
Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond to the board member questions?
I do.
Okay, please proceed.
Good afternoon again, Chair, Commissioners. I believe there are just two outstanding issues here. One was the initial proof of service. We just provided that again via email to the project manager. And the only other outstanding issue was the typo in the statement of facts, and we can correct that and provide that to the project manager this week.
Great, so I see Mr. Ruffin's hand up, and I'm assuming he's going to be saying he received it. So go ahead, Daryl.
Yes, so I'm just gonna let you know that I received it and I also forwarded it to you, to your email.
Thank you. Okay, great. Any other comments from commissioners, anything? All right. then.
Okay. Members of the public?
Yeah, members of the public.
So members of the public, and it's 126-10BZ, 856 Renson Avenue, Brooklyn. Thank you, Chase.
So if you would like to speak on this application, please dial in. So it's just that tiny little typo, and otherwise I think we had everything. And I just want to alert council to the fact that this is a request to amend the hours to 24/7, our council. And I don't see anyone else joining in. So then I would like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Application is closed for decision.
Thanks.
Okay,
Well,
next,
Yeah, sorry, I just want to say we'll try to put it on as soon as possible, okay?
Thank you.
Thank you very much for calling in.
Next item is 19313BZ, 4770 White Plains Road, the Bronx.
Aye.
Okay, oh, geez, why did it go out? Okay.
So Ms. Fullader, you're doing this one again?
Yeah, and Greg and Mr. Diamond, Ben Diamond should be on. Those
Okay.
two are the two, you mentioned them before.
Yeah, Greg Wiz Diamond. There he is. Okay. All three on mute. And so, Mr. Galazeski, sorry, I mispronounced your name. We need to swear you in. Did he disappear? Oh, okay.
Oh, he's there. Can you all
Okay.
hear us? I just want to make sure everyone can hear.
Yeah.
Can you hear? You can hear Mr. Diamond with Mr. Galazeski?
I can hear.
I need Mr. Galazeski.
It's
Hi.
Mr. Greg Yalachowski.
Okay.
Can you
So-
say your name, please, clearly, because we keep mispronouncing it?
Galachewski.
Galacheski. Close enough. Okay, thank you, sir. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly, board member questions?
I do.
I do. I do.
Okay, please proceed, Ms. Fullader.
Elise Fullader from Eric Palatnik PC. I just spoke with Greg and he has a lot of your answers, so I'm gonna go to Greg.
Okay. I just wanted to clarify a couple of things in regards to the DOB set of plans and the approved BSA plans. In regards to the landscaping, what was the concern around the site? There's, I believe, arborvitaes that is specified around the three sides of the site, and then also down the middle of the parking area. That area is actually a difference in elevation between two levels of parking. Those should also be reflected on the DOB plans, page 5 of 9.
Okay, hold on a second. Let me get there. The issue was that, for instance, the BSA set doesn't show that fence. So it should be, if you want to install a fence, it should be shown.
The fence between the two parking levels, correct?
Yeah, exactly. So the reason you have it is it's because there's two levels there. Is that why?
Yeah, fall protection.
Okay. And then the other thing that was different is the amount of vegetation at the rear lot line is different. Because you kind of change the shape of that planting bed.
Okay, I'm trying to find
Let me see.
the difference there. So we have a 4-foot wide landscape buffer with a 6-foot tall ornamental fence. That should all match as well.
I'm just going to go to the drawings. I'm sorry, I'm doing this a little bit from memory.
Yep. I know there isn't a specific dimension called out on the DOB plans. We could add that and amend it with DOB to match, but it should also match.
Okay, sorry, I'm mixing this one up a little bit with another one where we had a similar thing. So really, okay, look at the proposed plan, the previously proposed plan, previously approved. You have 3 double stackers
Against the building? Yeah.
against the building where you used to have, where now you have like 6.
Yeah, so we put that in, the engineer put it in because he wanted to create handicap spaces, but we'll revert back, we'll amend that filing to reflect what's on the BSA.
I don't know that this board has an issue with it, but they have to match.
Yep.
Okay?
Yeah, I don't think it's required, so I'll review it and I'll have him likely amend his DOB set to match the BSA set.
Okay, so the easiest, so we don't have to think about it, is if you make the DOB set match the BSA set. However, there was no fence, and obviously you need the fence, and there's the steps. There are actually steps shown.
Yeah.
And maybe the idea was, oh, you know what? And maybe the idea was that the planter was going to be, the effectively the fence. And now you're doing it a different way. It seems, I don't know. But then the other,
I don't,
yeah, because there's no fence.
I don't think the BSA said really took that into consideration. So
No.
I think it was just basically a curbed area with the landscaping, which from a legal perspective may not be enough.
So the other thing that I was looking at, because for me, my running theme is always the front to back depth of the actual planting bed. So what I was seeing was, if you look at the top of the drawing, of the approved drawing, you have a 4-foot wide front to back depth that doesn't include whatever that thing is, the steel ornamental fence. So it's the fence, and then you do your first beginning of your measurement, and then you move to the front of the planting bed, and that gives you 4 feet. That would give adequate planting thickness. And then you do the with the one that's sort of separating one level to the other level of parking. So I want to make sure that we're not getting short shrift on the width of the planting beds. So if you could, and then the other one that's along the property line on Enfield Street, that's measured on the approved drawings as 7 feet wide in depth front to back. So again, it should be the same on both sides. Actually, it's both Enfield and at the 242nd Street. Okay.
Correct. Yep. Yeah, the DOB plans always like that.
Great. Okay. Thank you. And then I don't think there was anything else. There's also an update. Oh, so there was a question about the building and how that's going to work. If the building is finished and occupancy depends on parking, how does that work?
Right. So construction still isn't complete yet. The building is partially occupied. They're hopefully wrapping up construction within this year. And the facility itself is leasing a garage, a parking garage that's about 750 feet away from the site, which is being used. And most of the occupants here also rely on public transportation.
No,
so there
but
isn't necessarily any.
yeah, but that may be the case. Zoning requires a certain number of spaces. My experience has been that when you're relying on another parking lot temporarily, parking location temporarily, the DOB makes you fill out and testify or certify to the fact that you're providing that temporarily until you complete the other location for the parking. Are you the architect?
I'm the architect on the project. I took over from the original applicant. I'd have to check with the engineer with his application to make sure that's happened.
Okay, so that's the thing is, can you provide us please with a copy of the document that you gave to DOB to confirm that you have this off-site parking lot that's going to be used temporarily until this parking lot is used? Because it's sort of not the deal at the BSA that you occupy your building and then you never provide the parking, which usually happens, right? We didn't waive all the parking, we only, okay, great. Commissioner
Correct.
has his hands up.
Yeah, can you also let us know what kind of occupancy in the building? Is it a medical? Is it an like regular office? What kind of like activity is done there? For the portion that's
Commercial office.
occupied, of course.
The commercial office.
Okay.
Do you script 6?
Yes, I believe so.
Okay. All right, any other comments from commissioners? Well, I'd like to go to the
Can I just ask a question, Madam Chair?
Go ahead.
Oh, I'm sorry, but the plans. So is he's submitting revised plans to us also?
Yes.
Along with the
So, no, so to the extent that, so the BSA drawings have to be modified to show that fence that represents the level change. That's
right.
The DOB drawings have to be modified to show the same measurements for planting as what was approved by the BSA. So the match. And then we also need that submission of the representation to the DOT that off-site parking is being provided on a temporary basis that complies with zoning. Okay. All right, so please, Chase, if you could put it on for,
Someone has their YouTube or something, please turn it off. Background noise. Thank you.
Chase, can you put that screen on for the public to call in, please? Thank you.
Okay, so we're discussing 19313BZ 4770 White Plains Road, the Bronx. Any members of the public would like to call in, the number is 646-558-8656. Zoom meeting ID number is 976-9265-6833 pound. You say, okay,
Pound sign.
okay. How much time?
I don't think we need a lot of time, but Greg, how much time do you think we need to revise the DOT? I imagine that's the hardest part. Or he put it on mute. I don't imagine we need so much time, but enough to go back to DOB.
It should be within 2 weeks.
This is enough to resubmit to DOB?
It should be. Although the way things are running now, maybe not.
Yeah, so I'm going to give you 4. Okay. All right, I don't know if we can close this. Can we? Fully occupiable. I don't know that there's anything substantive. Does anybody have an objection to just closing this? Can we make sure that everything's nice and tidy? Okay. Okay.
So we need the plans and that documentation to DOB of temporary occupancy of parking.
Yeah.
Okay.
Okay, great. All right. So thank you very much. Motion to close.
Chair Perlmutter? Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, next item is the continuing cases from this morning. 55, oh, I'm sorry.
1 second. Can you give like a 5-minute break? Because something I need to take care of, and I think commissioners might appreciate it. 5 minutes. Okay, so just a 5-minute break, and then we're going to go to the morning cases, correct?
Yeah.
Okay, 5 minutes. Thanks.
好，这里是中国总领馆。
I am ready.
Chase, Chase. There's Chase, okay. Okay, you ready? We're waiting for one commissioner. We have everybody? Okay. So this is the Board of Standards and Appeals public hearing.
Oh, I don't see Nather. Commissioner Sheta.
Yeah,
Commissioner Sheta, acknowledge your presence, please. And Otley Brown, I see her name, but not her presence. There she goes. Well, now for sure we have a quorum, but I don't see Commissioner Sheta. I'm gonna text him just to tell him to come on.
I'm back.
Are you back? Good. Thank you. All right, we can start.
Okay, we're resuming the Board of Standards and Appeals public hearing. We are discussing the two cases that we were not able to discuss in the morning session. The first item is 5597 BZ, 7636 164th Street, Queens.
Okay, we had already discussed it in review session, so now we're in public hearing with this one.
Right.
And Bell's office. I guess it's Fay Ann. She has her hand up. We're allowing her to talk. Go ahead, when you can.
Oh,
Do you affirm to tell the truth? Fay Ann, are you visual?
sorry.
Okay. You're the only person coming in, right?
Yes.
Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions?
Yes, I do.
Okay, I'm just waiting for Madam Chair.
No, I'm here. Sorry.
Okay, proceed, please.
All right, Fan Baton from Sheldon Lobel PC for the applicant. We attended, I attended this morning's review session. I know there were just some minor comments which we could address in a submission. As for the proof of continued use, we could provide a photo. It's been in use since we filed. I know that the term expired back in September 2017, so we'll just do our normal, maybe Google Photos or something like that. We'll be happy to provide that information. As for landscaping, I don't know if I want to be the ideal person, set the new standard. But yes, we will provide the site plan with notes regarding the grass in the rear of the building. So we'll add that to the site plan. As for the curb cuts, the curb cut is still necessary towards operations. And I know that there were concerns at the initial hearing regarding the parking, and that's why we put that no parking sign there. Well, we painted it on. I think though, after some of the suggestions about the bollards or the wheel stops or chains or something to prevent the cars from going on the sidewalk, it'll be clear where cars could park and where they can't park, although that sign the paint will still be there. The applicant will most likely choose the most cost-effective method of making sure that the cars don't park over the property line. Obviously, it's a small business, and we want to make sure, they could afford to do that. I think,
just in terms of that, so wheel stops are the easiest way to go, but they should be fixed, so they bolt them down, okay? Not just throw them down and then they get moved, okay?
Yes, and we'll make sure to put that within the property line. Right now, the asphalt is still there over the property line. The notes it's written on the proposed plans to remove it because it requires DOT approval and such. So we'll just make sure that the wheel stops are within the property line. And I understand that there were comments regarding the parking spaces and the layout that they currently are right now. So if they have to be restriped, then the applicant will do that as well. And then we could provide photographs. Yeah.
One thing with regard to the wheel stops, they would have to be a foot or two in the property line, so that the vehicle bumper wouldn't go over. Right. So I'm not sure if it's going to be a foot or two, but I'm sure your architect can figure that out.
Right, and I'll talk to the applicant and the architect regarding that. We'll provide photographs also of the area where the tires used to be from the satellite images, and I think a site visit over a year ago. There is that chain link fence there and the dumpster, which I know was noted on the plans, but we'll provide additional information regarding the trash enclosure. I'll just make sure that the architect provides that, and we could provide photographs as well of these conditions. And then I think finally, sorry.
There's a fence that's shown in the drawings. Shown in real life, but not on the drawings, right?
It says there's a 6-foot high chain link fence on the plans. On the site plan on A1, it says 6-foot tall chain link fence. But I'll just make sure it's clearer on.
I have a question. I'm looking at the photo that was submitted, which shows the no parking. If you look all the way in the back next to the building, to the left of the building, there is a fenced, chain link fenced, opaque like a gate. Where is that located? Because that's not corresponding to the plan.
Right, so I'll make sure with the architect, I'll double check with the architect, because even though there is it says that there's a chain link fence on the plan, it's at a different angle than what's actually provided, what it seems like from the photograph. So I'll have to confirm with the architect to make sure.
I think you have the chain link fence that's along the rear that separates out the parking from the grassy area, but you also probably have another fence next to parking space number 17 that's cordoning off that triangular area next to the building. So if you can just confirm that and indicate that in the plan.
I think you may not have as many parking spaces as the drawings show, because
5, 6. Oh, there's 6.
no, but then where are they parking if there's a fence and they're angled parking?
It is 1, 2, 3, 4, 5, 6. Yeah.
So the only way that you can actually see it, because we don't have a complete set of photographs of the site. 5, 6 spaces, maybe not angled, I don't know. And then you hit that fence that lines up with the building, the front of the building, and the drawing itself shows.
I'll confirm with the architect and the applicant.
I think they changed it from angle to straight in, and that's how they got the 6. Anyway, okay.
I'll check with them. And I think there was one more issue there was a question regarding the sign analysis, and I think we didn't do each frontage because there was only one illuminated sign.
But are there other signs?
There were the non-illuminated, and they are noted on page. I think we didn't do each frontage. A sign analysis was previously provided. I could ask for it per frontage. It never went over the total amount.
So wait a second, you didn't do per frontage for which? The calculation sheet or on the drawings?
On the calculation sheet. So the calculation sheet just had the total of all signs. There are total 4 signs that are 75 square feet, 1 illuminated and 3 non-illuminated. They are dimensioned out on they're also dimensioned out on page A6, but because I believe the sign regulations are 150 square feet per frontage, and it never exceeded that for the total. So we didn't provide per frontage.
Yeah, and I don't think you have any signage along 164th Street. I'm going back from my site visit, but I don't
believe it's there either. So, I could confirm that, but it's not, the total amount doesn't even exceed per frontage. That was just why we didn't separate them out. And the 3 of them are on the building.
So this is the part that I can't figure out. A6 shows 3 sign number 1, 2, 3 or something like that. I don't see the signs numbered in the plans. How do we know where those signs are? Illuminated sign 1, 2, 3. But I don't know, how do I find those signs?
I will double check the plans, but if not, I'll make sure that the architect includes them on the site plan as well to show where they're located. Because it seems like if I'm looking at A6, it actually seems that the signs are citing to itself, the same page.
Yeah.
So I'll confirm with the architect.
Anything you want to add?
Fire department.
Chief Daly has a comment. Yeah, go ahead.
Yeah, Madam Chair, I heard your comment earlier regarding showing continuity. According to my fire department record, fire department has been conducting annual inspections at this site since 2004, and they've been current with all their FDNY permits for the past 16 years. Is that helpful?
Sure, always.
Okay. So, should I write a letter to that effect, or?
No, I think
My comments.
I think testimony is good enough that you are okay with the site, right?
Yes, ma'am. Yes.
All right, that's fine. Thank you. I would like to then go to any other comments from commissioners or staff? Okay, so then I'd like to go to the public about this one.
Okay, so we're discussing 5597 BZ, 7636, 164th Street, Queens.
Okay. All right, so Ms. Patan, how much time do you need to submit all of this? Unfortunately, because we don't have proof of continuous use, which is a finding, we can't close this, but how much time do you need?
I don't think it would take much long for, the architect was recently out there, so I'll just make sure we could get photographs and update the plans. I would say maybe 2 or 3 weeks. I just don't know how long it would take for the wheel stops.
Oh, right, okay.
Whether that would be a proposed condition or an existing by the time of a vote.
Oh, I see. What's the preference of the board? Because that would determine, I mean, it's not to say that I can put this on immediately anyway, because we have very full calendars coming up. So that probably would give you enough time to put the wheel stops in. They can be very, how much they cost when you buy them from like Home Depot. They're not that expensive.
Would it be okay to set the next date? I mean, you would have to close and then do another hearing for vote. So by the time of the vote.
Yeah, that's true. That's fair. Yeah, perhaps. Yeah. But again, we have a very full schedule. So it's not going to be like next month necessarily. Right. So that might give you enough time. All right. So should we just say 4 weeks to submit? Just so I have an idea.
That should be fine. Yes.
We're good? Okay, next. Move on. The next case is 24503BZ, 16011 Willets Point Boulevard. There should be 5 members of the team.
Someone has, sounds like an airplane outside, so can you mute? All right.
Maria. Is Juan joining us too? You're muted.
Sorry, I was muted. Yes, Juan is joining us.
Okay, and Jared and Mr. Alides. Okay, Mr. Miller is already in.
Okay, could everyone please state their names though when they speak, because we're being recorded. We need to get on the record. Okay, please proceed.
Maria Papasevicius of Seifert Shaw on behalf of the applicant.
Let me swear you in, please.
What about everybody else? Who else is here that's going to be sworn in?
Mr. Miller and anybody, where's Juan?
Patrick Miller present.
Okay.
Jared Jones from Bowler Engineering should also be here, and Juan Reyes.
We don't see him. They're not here yet. Maybe you want, oh, someone just, last 3 digits, 211 in their phone number. Do you know who that is?
211.
Is that Joe Sweeney, maybe?
Oh, Joe Sweeney, maybe, yeah.
Okay. Last 3 digits, 211. Can you identify yourself, please? unmute yourself and identify yourself. The person whose phone number ends in 211.
Please state your name. Hello?
The person with last 3 digits, 211 in their phone number. Can you state your name, please? Hello? Okay, let's proceed. I don't know what to do. The person whose last 3 digits are 211, please state your name. State your name, please.
Hello? All right, you want to move on?
Let's move on.
Yeah, okay. So Ms. Parasova and Mr. Reyes, Mr. Miller, I don't see your other person, but raise your right hands.
I think Jared Jones says that he's on the call now.
Well, what's his phone number?
He's in with Patrick?
No.
No, I'm,
Oh.
no.
What's his phone number? If he's on the call, then he's the one with the 211, unless he's.
His mobile is last digits 9642.
No, so he's not on. He might have called into the wrong
The morning number.
morning or another day or I don't know what. But if he's not hearing us talking, he's not in the case. Anyway, we don't see him, so he's not here.
Do you want to move on?
Yeah, let's move on.
Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes.
Yes.
Mr. Reyes?
I do. Can you all hear me?
Okay. Yeah, I hear you, Juan.
Okay.
Okay, please
Oh, my
proceed.
video's not going here.
Okay, oh, there you go.
There you go.
Hi.
Hi.
Hi. Please proceed.
Okay, so we heard the board's comments at this morning's review session. To go first, I suppose to the sound data and the comments on that sound data. So the data we submitted, it was meant to respond to the board's questions regarding the specifications on the speakers, the AVC control, and more information on how the sound manufacturer actually got the data that we had included in the plans. So that was all meant to do that. Also, in response to the administrative notice, which came out after the last hearing, we had submitted additional documentation and support to meet that. And specifically, because this is a proposed menu board and system that hasn't actually been installed, we were following the administrative notice, the section that said that because it's a proposed use that would be utilizing sound systems to be installed after the application is granted, we were basing our data on analytical and mathematical models that could then be verified by the board if requested using a field measurements after they had actually been installed. So that was kind of the intent of what we had submitted with the data. And I'm not sure if you want to go through each of the
through this, but can I give you some friendly advice about managing a case?
Sure.
Try to anticipate questions, knowing how the board has been historically responding to not just your own case, but other cases. So when you see our calendar and you see another case coming up for the same kind of request, listen to that case so you can hear how the board is responding generally to those questions, and don't follow like line by line just to satisfy your own, like, let's say, don't follow so closely line by line to what you're being told to do. Try to imagine what you may be asked to do in the future, because it's your job to make a case. So in your place, what I would have done is I would have gotten the manufacturer's information and I would have read it very carefully, because that information actually isn't that helpful. It talks about, reverberation against a building that's within 100 feet, and we have a building that's 45 feet away. So obviously now I didn't even think about reverberation, and then that brings another thing. So I would think about whether that testimony is actually helping you. And in fact, that engineer's report, which was very professionally prepared for the general use of that general object, actually said things like, we can't speak to what the local codes are or the local application or how tall, how loudly someone speaks and all of that. You have to read those materials and be analytical about it. Say, imagine how will the board react to having read that stuff? That's the first thing. And then the second, so in your case, what I would have done is I would have gotten that data from the factory and so on, read it and decided whether I actually wanted to submit it or all of it or ask for something very specific. And then I also would have done the field tests, because even if you're relocating the speakers and you're using a different speaker, we are still interested in how is it affecting the neighbor. And so field tests to fulfill the requirements of the administrative notice, where you say, in addition, like belt and suspenders, we went and we measured at this many feet at the top of the fence, higher than the fence, and based on the existing speaker, which we know is not as good as the other speaker, we found this out. And maybe the answer is it's fine. And you would have said a worse speaker is fine in this location. But the reason this has gone on so long is you're not listening to, you're not sort of considering how the board is going to respond. This is a very technical board. We're able to review all of these materials and you're not anticipating the response. So I really recommend that to not have another case that goes on for days and days and days, but is more like the one we just heard, where they come and it's one hearing, that you do a better job of anticipating. And Commissioner Sheta? Unmute yourself.
Yeah, I did. Thank you so much, Chair. I just want to mention that when I expressed my opinion during the review session, I wasn't fully aware that the system is not fully installed. So I would say field testing for the actual proposed system would have not been possible. But at least I was anticipating something to be measured in the field. And instead of you've done the measurements somewhere else, I understand you probably use the same speaker or the same menu board equipment, but the measurements were done somewhere else, totally different conditions. If I want to do this honestly in a technical way to extrapolate to the proposed future conditions at the site that's going to be existing at the site, that would be like a really huge task to do away from the site. So my anticipation was measurements on site, at least you're going to have some features present there, like the fence is there, the height of the fence is there, the neighbors are there. You could have measured to the neighbors with even a totally different speaker, even with the existing speaker. And you could have showed us in a certain manner that the future conditions impact would be such and such. But since this is not being done, I'm not sure if we want to give the applicant really good amount of time to install, give him a year, they go install, measure, and then they come back, or probably just maybe they withdraw and come back later.
No, okay. So this has been going on too long. It's a very frustrating case because it's been going on too long. And the administrative notice was created based on the frustration on this case, right? That we couldn't figure out how to get people to do proper measurements. So maybe we should just tell them how to do it, right? But I don't want to belabor this. we talked about a long time ago, giving them a 1-year leash where they install, we see how it's impacting, and then they come back and we hear from the community and we hear from the neighbors about whether it's working. And if it's not working, then further mitigating elements and maybe even a further reduction on hours and so on to accommodate that. There's a limit to how much more guesswork we can do. And I think we're all exhausted from this case. So I would want to just do that, but I want to go, before we continue any more about the sound, I want to go to the reality of the zoning district boundary. I don't know what to do about this case. I don't know if we're allowed to even permit it at this point. And we talked about this many weeks ago and it was never addressed.
So just in response to that, I mean, our team, that may have been an error on our part though, but we did not realize that this was a concern for the board, and we did not hear it raised. As far as the split lot condition, it was referenced in the prior resolutions that were approved. DOB has approved this, so we can certainly go back and look at the implications.
Explain how it's legal, how this board has the authority. There's a team of lawyers there in your domain. Explain to me as land use lawyers how it's legal that this drive-through be located in an R district. I was doing some research for you, and the idea, and this, I find this very upsetting. You're waiting for the board to pick up defects in your own application. The application materials, the statement of facts, as I said in November, didn't even mention that there was a split lot condition. How? When you're looking at it, you should say, oh, look, there's a split lot condition. I wonder how this was permitted. And the fact is that the very first resolution that's included in your materials said, this is an application for a drive-through special permit and a special permit to extend this district boundary over 25 feet, which would have cured the drive-through condition. And then it was never applied for, or if it was, we don't see it mentioned in the resolution. So explain to me how it's legal. I don't know the answer. It's not my job. It's your job. You represent this property owner. And when you come before us and you're asking for a waiver, the waiver has to be within our authority. I don't see how this waiver is in our authority. I'm not saying it can't be, but I don't know how it is without a little help from counsel, in other words, your counsel, to help us get there.
We will research that point.
Okay. Anything else? Commissioner Shabeta, did you want to add something?
No, I think that you said it all, Chair. I think it really shouldn't take you much time to give us some precedent. And while I can't say I would blame you for not bringing it up, but it is something that we see now, and I think we should have a response to it. I think it was brought up in the last hearing, if I'm not mistaken, according to my notes, that we did bring it up. But I think that that could be rectified with some research.
Hopefully. I'm excited to see how rectified, because I don't know.
Hopefully.
Just wondering, just saying. Okay. All right then. So I don't want to belabor all this. The leash will be 1 year, but first you have to cure the potential jurisdictional defect. So I know we have someone who was calling in to speak on this. Do we have Mr. Sweeney here? No. Maybe he got exhausted. Is Mr. Alexiadis part of your team?
Yes.
Okay, I'm going to allow him in. Sorry, allow to talk. And then I'm going to allow phone number 211 to talk again, because I don't know. So, Mr. Alexiadis, did you want to speak?
Yes, hi, members of the board. My name is Nicholas Alexiadis from Bowler.
Okay, could I swear you in first, though?
Of course,
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, or to respond honestly to board member questions?
I do.
Please proceed.
So earlier, I believe we were discussing the volume requirements over the property line. I just would like to comment on that a little bit in regards to the exhibit example that we received and how it applies to our site. So we prepared our sound exhibit based on sound data we've received from HME, who is the menu board manufacturer. I understand your concerns with providing a site-specific analysis, and there are some generalizations between, some assumptions made within the report. However, these are approximate values. They state that based on laboratory measurements and field measurements, the sound levels were within 1 decibel of each other. So we don't expect the sound to deviate much from the vendor provided calculations, which we can provide actual measurements once the system is installed. However, before it's installed, we're deferring to the engineering white paper that was provided to us for these products that we propose to install. And another comment I know was brought up previously was the reference to the SECRA manual, which proposes or specifies a maximum decibel as an acceptable level for neighborhood disturbance or ambient noise. It's acceptable to encumber adjacent properties. So, being that there's no defined decibel level of what's acceptable, we're deferring back to the SECRA manual, which provides that decibel measurement. And our sound exhibits had demonstrated that even at a 2nd-story window on an adjacent property, the loudest decibel that could ever be generated by the microphone, by the speaker to be proposed, according to the engineering data that we had at a sound level of varying heights, was 55 decibels. So based on the SECRA manual, that was the acceptable general exposure for residencies was 65 decibels from 7 a.m. to 10 p.m. and 55 decibels, which is what is currently proposed, between the hours of 10 p.m. and 7 a.m. So, the sound exhibit that we have prepared demonstrates that we are below the 55 decibel ambient noise, above that sound barrier that's being proposed on the fence. Below the fence, it's approximately 27 decibels, but that would be, for example, someone sitting in their rear yard. But the worst case scenario would be somebody in an upper level of the adjacent building with the window open. And again, based on the precedent and the sound decibel requirement from SECRA, that's what we were showing compliance with for that part of the comment.
What do you mean by precedent?
The general acceptance levels from the SECRA technical manual for noise encumbrances on residential properties.
Right. So as I said, we don't use SECRA as the standard. We use annoying as the standard, and because this case has gone on for so long, you may have been. We heard another rather horrifying situation on a McDonald's, where a neighbor reported every night and sent us constantly video clips of us being able to hear the menu board and hear the person ordering from the menu board, and in addition to which we heard radios blaring loud music at all hours of the night. And so, testing and the distance between that person's window and this book and the menu board is approximately the same situation. It may even be in that other case further, and the audibility was remarkable. So we're not looking at seeker, we're looking at the ability of a neighbor to tolerate, more than tolerate, to live their lives without being imposed upon by a commercial use that is not taking adequate concern and care for the neighbors. I'm going to recognize Commissioner Sheta.
Thank you, Chair. I believe we looked at a previous submission was made, and it was like a dependency on the window panes to mitigate sound. And we made it clear before that that's not going to be accepted. And I recall at that hearing, we said that the increase at the property line should be minimal. That's what we're calling for. And I'm not sure, honestly, I'm not a sound engineer, but I have some physics classes. Why would it be impossible to like plug in on site, do a field experiment on site with something similar to the proposed menu board, something that's a speaker that's gonna generate more or less the same sound pressure level, similar to the proposed menu board, and just do some measurements 2 feet away, 4 feet away, 8 feet away at the fence, above the fence, even in like into the adjacent property if they allow you that, and then project from these data to the future. That would be like, if you've done that, I could have been more sympathetic with you because you're very close to the actual proposed conditions. But since you like counted totally on a theory, you didn't translate from like close field conditions to actual field conditions. You translated from a theoretical measurements somewhere else at the manufacturer location or I don't know where to your proposed future field conditions. That's a big translation, and I'm not seeing a reason for that.
Okay, I think this is more of a, rhetorical, hypothetical discussion. We didn't get it, and I don't want to belabor this anymore. So I would like to invite, I think we already did invite members of the public. So who is last? Is that Mr. Alexiatis on another phone?
I'm sorry, could you say that one more time?
Yeah, because I think that's you speaking. Does your phone number have the last 3 digits, 211?
It does
No,
not.
that's Joe Sweeney.
I think that's Joe Sweeney.
Okay, so let's let Mr. Sweeney speak. He's been so patient. He's been here since 10
Oh,
o'clock.
no. Yes.
Yeah, just a minute, Mr. Sweeney. So members of the board, Mr. Sweeney submitted a letter. I don't know if you've seen it yet, the community board letter.
No.
Okay, so I just want Mr. Sweeney to mention it as he speaks.
Go ahead, Mr. Sweeney.
Again, my name's Joseph Sweeney. I was the chair of this committee when it came to Community Board 7. I've been chairing this for the past 15 or 18 years every time that the variance came up. I will have to say, appreciate the SA's response in reference to the noise situation there. I do want to say in defense of that McDonald, over the years, before we had our public hearings, notices were sent out to all the community as by law. We've never had anyone come in front of the board. We never had a telephone call made to the board. We've never had any comments related to the particular situation as far as the noise. I did the last time around. I went to the closest 10 homes next to the McDonald's at that time with their existing board. No one had any problems with it. But of course, if they need to improve the situation, so be it. What I was calling it because the last time I mentioned that the board was very interested in having the stop sign placed at the location. And I know that McDonald's has agreed to it. I wanted to be a little bit more specific that stop sign be like an 18 to 24 inch solar powered sign, octagon sign, stop sign that met the MUTCD standards. I wanted to make that more clear this time because they didn't want a sign put up, a small little sign that was 5 by 5. But more of a large sign that would operate. And also, I would like to indicate that we're looking for that the sign that does exist operates at nighttime, but be repaired within 24 hours, because some of these operate with batteries. The batteries go bad after 3 to 4 years. A lot of different places, they do not replace the batteries, and it defeats the purpose of having that solar powered stop sign. The other thing we're asking is that in reference to the speed bump, which they agreed to put in, that speed bump, because they do wear down quite often within a year or two, that they be replaced at least every 2 years or before when they do wear down, because if they're not replaced, it defeats the purpose of the speed bump. And that's basically what I want, my input today, and what I've been waiting to speak about today.
Thank you. I so appreciate your incredible patience and apologize for this morning's.
Well, I appreciate you guys, you did, especially in reference to this morning's Zoom output.
I do have a question about the stop sign, because I'm looking at the drawing and I don't know if they shared with you the most recent drawing that shows the speed bump. Where is the stop sign that you are talking about?
It's at the exit.
Proposed solar proposed stop sign.
Where is it?
It's bubbled out.
Lost you.
Oh, sorry. In the proposed conditions plan, BSA 2, it's a little bubble by the end of the drive-through.
That's where it should be placed, yes.
Yeah, there's one
It's
that's.
is it the one along the Francis Lewis Boulevard exitway from the drive-through?
Yes.
Right. So it's right at the Francis Lewis Boulevard next to the building. There's a cloud. One says proposed solar powered stop sign, and then there's a proposed speed bump.
So
on BSA 002.
All right, I'm looking at a different cut and paste. But anyway, my question is, what's the reason it needs to be solar powered?
Because of the at nighttime being dark there. There has been some cases of people just picking up their food and just driving out. And to stop that, we felt that we talked about it last time. We originally wanted it lit so it could be seen, but we felt that it was solar powered, and that because something about the electrical lines, they thought it would be better to have it solar powered instead of running electric underneath and coming up. So it was a blinking solar powered, and they agreed to that. Because it becomes a safety issue as people pulled out. Those were the two reasons we wanted that the bump put there, so people don't get their food and just go back right out to the Francis Boulevard, and that stop sign being large enough that as people enter the drive-through, it's big enough that they see in advance, oh yes, I have to stop when I pull out.
I get why you'd have a stop sign. My question was, why are we using solar power, except it's in the middle of the woods or something? You're in a building that has electricity. Why wouldn't
Well, that's what was suggested, and I don't know, but that's we mentioned that we want solar powered because there was discussion about the electrical issue, and so we, being lay people, turned around and said, well, if you can't put in the electricity, then put in a solar power sign.
This was during your hearings at the community board?
Yes.
Okay, so this is easy. We don't need to listen to those things. This is McDonald's.
Can I ask for, I know we're having an issue now with some of the borders or all that. By the way, this is Patrick Miller speaking. I apologize. And the first thing, I know you said it was McDonald's. It is Miller Systems. That's my business. I do business at McDonald's, but I'm the guy who runs the business. It's a small business. I'm a single store operator. Could we get a little bit more time so they can go through all this with the noise complications and all that? I will say this. I've never had any complaints, and Joe Sweeney can attest to that. We've never had any complaints I participate with all the local schools and fundraiser nights. I do what, I'm an involved operator. I'm a single guy. I don't own 10, 15, 20 stores. I own one store and I'm involved. People know who I am. And this isn't a just do what everyone says. This is me getting involved in the community and doing the right amount of things. Listen, I've been away. I've been in other states and McDonald's come up to me. Hey, what are you doing away from the store? So I don't want this to think of this is a 20 store guy who does everything. I think Joe speaks to it all. I do everything that the community, I'm involved. And this really confuses me what's going on through this whole thing, seeing that we did have a member, the closest community guy, the closest neighbor saying, Mr. Miller is a good guy. If there's a problem, he'll fix it. So I understand there's things that we have to do moving forward, but I plead to you, we're going to be going in front of the board by the time this is approved and built. It's going to be quick again, but it's very difficult for me to listen every time we expand this thing out. And the 1 year is just, I've spent a lot of money. I spent 4 times the amount on lawyer fees to get this done that it normally done in the past. And again, I work with the community board. I don't look at the community board as an adversary. I look at the community board as a partner of mine in getting things done in this business. They tell me what they want, I do it. So I just would wish that maybe with that 1 year, we're going to be back soon enough. And I will tell you, the neighbor is, I've always done the right thing by the neighbor, whether it's remove trees, to help get him what he wants. I would just, the one thing I would ask just for monetarily, because this isn't McDonald's Corporation flipping this bill. This is a one store, single store operator that I'm going to be back in front of the board in, I think, 2 or 3 years already. By the time this is all said and done, the building, that's my request. And again, I appreciate your time. And I know this has been a long road to get through this, but it has been with the help of the community board, with the help of Queensborough and everyone else and you guys. It's just, it is taking a financial toll on me. It's not McDonald's. It upsets me when they say it's McDonald's. This is Miller Systems. I'm a single store guy who every time we go back, I get bills from lawyers and I want to get it right. I think I've done it right with the community, the neighbor, the guy, the only guy it's really going to affect, writing a letter to you guys saying, hey, Mr. Miller will do the right thing. We have no problem with whatever he wants to do. And we're stretching it out. And I get it. And I would just ask that maybe we can, so at least I can try to make some money to pay some of these bills back. There's other things involved, but that's my 2 cents on the matter. And again, listen to the community board. They'll tell you I do the right thing by the community. This isn't all about, me. This is about the community. And we got this drive-through because the families in town wanted a drive-through. And I had a couple thousand signatures. They wanted a drive-through. We provided, we move fast and we work with the community board. We work with the town. And I would just ask that consideration moving forward.
Understood. You know what? We do appreciate the plight of small businesses all the time, not during this very strange time. At the same time, the question is, it's the impact of a commercial use on immediate residents. And though your neighbor may not be complaining, what I've learned about a lot of these locations is that neighbors in, let's say, less than wealthy neighborhoods don't complain. They think that that's what they have to put up with. And then they're happy when someone plants a bush. So what we're trying to do is protect the neighbors as much as we can. And we also did see from our own observation the terrible impact on traffic and on pedestrians. So we're trying to adjust to all of that. And at the same time, you're trying to expand your operations and so on. And so you need to play in both directions. So, but what I would say is, I don't understand the idea of a solar stop sign, because if it needs to be fixed and replaced all the time, then that's something that's not going to be operating. And to run a little bit of conduit to a stop sign, I'm sorry, I don't really understand what the issue is with that, since you of course have menu boards that need power, drop gates and things like that that need power, like all of these different things. Why in the world would one stop sign be the end of the ability to do this on hard wire? Commissioner Sheta has his hand up.
Thank you, Chair. Regarding the stop sign, I believe it could be operated like in a dual manner. Both they could put it on solar, and once if there is something wrong with it, it might be able to switch to like a power feed. Regarding the sound, I'm not sure if again, Bowler, can you go there and do field measurements?
No more. No, I don't want to do any more field measurements or anything, right? We couldn't get what we need. We're going to do this on a short lease to see how does it work in a year. It's the only way. We've been waiting for measurements already for X number of hearings and 4 adjournments, and it does cost money to do this, and we can't get what we want. So I don't want any more. I can't read another report about this place. It's just, I only want to know that we have the authority to allow this, and that's the end of the studies. And going forward, we're not going to allow studies like this. We have the administrative notice, and we're going to be very clear on what's required. And unfortunately, this case was part of what taught us that we need to have a clearer scientific approach to how the studies are done.
I'm calling exactly actually to what we're asking for in our administrative notice.
But I don't
what I'm
reports. That's what I'm saying, because we've been at this too long, and I can't have it be, what are we? There were a lot of adjournments for whatever reasons I've already forgotten, but we've been at this. It's 10 hearings. I can't have it be 11 hearings about the sound system. And we already know that we have a lot of issues with the sound systems and the potential for disturbance for other reasons. So it's just enough already. But we do have an outstanding legal question, and I don't know how to resolve that. And unfortunately, it's going to drag this on for at least one more hearing. Commissioner Shanda.
Okay. Comment on 2 things. One is with regards to the stop sign, whether it is solar or whether it's electric. I think what we can put it as a condition saying that this has to be a stop sign that is visible and lit, and whatever method they apply, it's their methodology, their method, as long as it is operational and as long as it is visible daytime and at nighttime. So we put that as a condition, and it's in the drawing as a note. That I really don't think it makes sense for us to get into the minutia of exactly what kind of technology that stop sign should have. That's one comment. The second thing with regards to the drive-through being in the residential portion, I was looking through the historic map of this lot just to see if there's been any change in the zoning map, and it has not. It has always been exactly what it is right now. A C overlay that is mapped to a depth of 100 feet, and the rest of the lot is in an R3. So it and the first resolution that I read, it says the site is in a C12 in brackets R32 and within an R32 district, an accessory drive-through facility in the so already it was acknowledged that this is a split lot zoning district with a C2 overlay on one portion and for the remainder C32. And the drive-through was always in the R32 portion. And the reason the first one was denied was because of the issue with the way the traffic was going to travel, and it had to be then partly through Willits and through Lewis. That's my read of it. And this is for the lawyers to explain the history and kind of take that off the table. That's how I read it.
Right. So I just want to add, though, that this board has seen cases where the board without authority granted something. Okay. So that's the first. But the second is that if you read the very first resolution where this case was denied, the request was to move the district boundary line over 25 feet to include the drive. And it was denied because of different kinds of traffic problems, that they didn't like the maneuverability and so on. So my question is, why was that request to extend the district boundary line taken off the table? And then why was it decided that it's not necessary? So if the board made mistakes, it doesn't make it legal. That's just what I have to say. Commissioner Shabeta?
Thank you, Chair. Thank you. I was persuaded by the owner. I think that he does take very serious efforts to be a good neighbor. Since we only have this one issue that's pending, would it be possible to close?
No, legal. It's a authority question. Do we have the authority?
It's a threshold matter that we cannot close on.
And maybe there's a way to solve it. I don't know off the top of my head how to solve it.
One question on the 1-year leash. I wonder if, since the only issue really is the sound and making sure the sound doesn't have an impact on the neighbor, I wonder if that could be limited to the sound question. Once we have this all installed, we could.
That's not correct. It's not limited to the sound issue. The thing that drew our attention initially was the community concern about traffic and the photographs that we see of cars backing up down the street to get into the drive-through. If that's not handled by adequate throughput and adequate opportunity to park in the lot, in the front lot or in the one in the back, then we have a problem with this case, because what's promised to us by the representation of the parking and consultant won't be the case. So that's actually surprising to me that you would ask that question when we started off with the question of traffic. Okay, so we just need to, so I'm going to then say, we're not going to get any more submissions on sound, on noise, on traffic. We are going to, we do already have the stop sign shown, as Mr. Sweeney mentioned. We do already have the speed bump shown on the drawings, as Mr. Sweeney mentioned. And the thing that must be addressed by council, and I recommend you reach out to our council and perhaps our executive director, who may have, and deputy directors who may have some history on how to address these things. You do that immediately to find out how to cure this. I don't know the answer. Okay. So then I think we already asked everyone from the public to speak. So we have, what's this list? Okay. Did Mr. Alexiadis want to say something else? Your hand is up. That's why I'm.
Yes, I just had one additional question regarding the sound, as it's going to pertain to a later, field study based on this area. Earlier, you had stated, that the board doesn't want to provide any nuisance levels of sound to the adjacent neighbors. I believe a lot of the confusion is in the definition of nuisance and what is that sound measurement, as it's variable in many different areas depending on the ambient levels of the surrounding neighborhood.
So we
I feel
just like we do the lumen study. The answer is the lumens have to be 0 at the property line. So why not the decibel level be no change at the property line from what is, you turn off the speaker without the sound, sorry, the property line without any sound, and the property line with the sound, the answer should be 0, no change.
So our question would be, how do you turn off, ambient noise of that area? Or for example, when you're doing a lighting study, how would you read a 0 level light if, say, there's a street light at that property line influencing that reading?
Commissioner Sheta.
Yes, I would do it. It's described in our notice. I would do it that way. I would monitor first the ambient noise, and then I would use the speaker for the menu board from the menu board with different ambient noise, like use it like at different times, events during the day, and then measure from the speaker. You could measure at the property line and see how much you're receiving at what kind of ambient noise, and then prove it to us that at the property line there is no increase in the ambient because of the use of the speaker. And I'm not sure with a property line that's 46 feet away, why this is impossible to achieve.
No. The property line isn't 46. The house is 46. The property line is right there. It's just opposite the drive. The property line is something like 15 feet away or something. The house is 45 feet away.
Hold on one second.
So anyway, but to be clear, Mr. Alexiadis, we are not asking for further studies on this case. Okay? We're talking about future studies and how we would handle it in the future, okay?
I believe that the fence is more than right there. I'm looking at the section and I'm looking at the plan. It's at least, it's further beyond 35 feet. Am I correct?
That's
Right.
correct. Approximately 45 feet.
No, that's to the house is 45 feet.
The house is probably 64 or maybe not 64 actually. Probably it's kind of 50 feet or so, but
I'm looking at the section on the noise study. The house is 46.8 feet from the menu board or from the, whatever that post is, the swing board, and the fence is 43 feet.
Yeah, that's what I'm saying. My point is, and I'm not a sound engineer. The rule of thumb is if you have sound propagating from a point and you measure 2 feet from that point and you measure X, and then if you go 4 feet, you double the distance, you lose probably something like 6 decibels. If you double it one more time, you lose another 6 decibels. If you double it 1/3 time, so if at let's say, I'm not gonna put any numbers here, but let's say the speaker output is X, which is 15 decibel, if you're using the AVC. So if you're using the AVC, you got the ambient plus 15. And then this is at probably 2 feet from the speaker. If you make the 2 4, that's 6 down. 8, that's 12 down. 16, that's actually like 18 down. So probably by 20 feet, the impact of the speaker will be gone. So I'm not sure why in this case, it's very tough to like get this through. It's 40 something feet away. If I'm doing this and I'm at geotech, I used to play with the dirt, not the sound. You go put a speaker there and measure at the fence, you're done.
Right. Okay, I don't want to go through this anymore. I would suggest that if Mr. Alexiadis, in doing future studies, wants to, for example, talk to the board, staff member to talk about how to handle these studies, we'd be happy to have a staff member talk to you about it. But at the moment, I just need to be very clear, especially for Mr. Miller, we are not asking for any additional studies. I just need the legal question satisfied, okay? So with that, I would like to then finish up this hearing. I'm not closing it because we can't. We have a threshold question. So I thank everyone for calling in and for being so patient in light of our technical difficulties this morning that were Eastern Seaboard wide. Okay, thank you everyone, and we'll see you tomorrow at 10 a.m.
So this concludes the public hearing for August 24th, 2 p.m.
Sorry, do we have submission dates or?
No, it's not submission dates. You're going to tell me how much time you need, but I'm taking a wild guess on how much time you need because you're going to need to figure this. I'm assuming a 4-week submission to clarify this.
We'll let you know what the submission date and the hearing date is.
Okay.